Hello everyone. In this series of video, I will discuss the historical development of modern constitution. So, constitutionalism in its modern connotation and responsible parliamentary institutions owe their origin and growth to India's British connection. It would, however, be wrong to presume that the British constitution or its parliamentary institutions as such were at any stage transplanted in India. The constitution of India and the parliamentary institutions as we know them today had an organic growth on the Indian soil. They grew through many relentless struggles for freedom from foreign rule and for establishment of her democratic institutions. And the successive doses of constitutional reforms grudgingly and haltingly conceded by the British rulers. From the perspective of constitutional development, the history of 3 centuries and a half that intervened between the formation of the East India Company and the setting up of the two independent dominions, one is India and other is Pakistan, under the Indian Independence Act 1947, may be divided into 5 periods. Number 1, first period is advent of the British. They were traders initially and they became rulers, and the period was between 1600 to 1765. Another period is known as the company rule. The period lies between 1765 to 1857. Third period is known as company to the crown. Period is 1855 to 1919. Fourth period is known as national movements and the provincial autonomy. This period extends from 1919 to 1937. And the last period is known as struggle and independence, and the period lies between 1937 till the independence of the country 1947. So now let's talk about the first period, that is the advent of Britishers and how they become from traders to the rulers. Like other Europeans, the British also came to India to trade, and British authority in India was established through a trading corporation. It was on 31st December 1600 that a company was incorporated by the name of the Governor and Company of Merchants of London, trading into the East Indies. The company, later on known as the East India Company, secured from Queen Elizabeth a royal charter. This charter granted to the company granted monopoly rights of trade with India and some areas of Southeast Asia for an initial period of 15 years. It laid down the constitution, powers and privileges of the company. Each year, all the members of the company were to elect one governor and 24 one-man committees. The management of the company was entrusted to these 25 men in England. Subsequently, these committees came to be called directors, and the court of directors was born. The company needed the power to make rules and regulations for the administration and management of its internal affairs, and also to attend to the needs of the natives. From the very first, the English traders assumed that they carried their own law with them. The company acted under the authority of the crown. Crown later on granted to the company certain legislative and judicial authority to be exercised within its possessions. The Charter of 1600 authorized the governor and the company to assemble themselves in any convenient place within our dominions and elsewhere, and there to hold court for the company and the affairs thereof, to make, to ordain and constitute reasonable laws, constitutions, orders and ordinances for the good government of the company and of its offices, and also to execute its laws by imposing or providing such punishments and penalties as they might seem necessary. The legislative powers of the company were, however, qualified insofar as the laws framed by them were in no case to be contrary or repugnant to the laws, statutes, or customs of the English realm. These powers, though originally modeled on the powers of ordinary municipal or commercial corporation in UK to make their own bylaws, are of historical interest. This germ out of which Anglo-Indian codes were ultimately developed. In fact, the germ of legislative power lies embedded again in 1601 Charter. Queen Elizabeth, which authorized the governor and company to make, ordain and constitute such and so any laws, constitutions, orders and ordinances as to them, or the greater part of them being then and there present, shall seem necessary and convenient for the good government of the said company. The subsequent charters granted in 1609 and 1661 contained similar provisions which continued, supplemented and enlarged the powers and privileges of the company. The Charter of 1609 made the original grant perpetual, subject to determination after 3 years' notice on proof of injury to the nation. The Charter of 1661 authorized the company to appoint governors and other officers of their government and empowered the governor and council of each factory to judge all persons belonging to the said governor and company or that shall be under them in all causes, whether civil or criminal, according to the laws of the kingdom, and to execute judgment accordingly. The company were also given command over their fortresses and empowered to continue or make peace or war with any people that are not Christians in any place of their trade. The Charter of 1669 transferred the island and port of Bombay to the company to be held of the crown for the annual rent of £10. The same charter authorized the company through their court of proprietors to make laws, orders, ordinances and constitution for the good government and otherwise of the port and island, and of course the inhabitants thereof, and by their governor and other officers to exercise judicial authority and have